of Appeals Division 1 is now in session.
Please be seated. We're here in our case 1CASA 21-0216, Fann versus Kemp. Before we begin argument today, we had a request to record the argument today by Capital Media Services. We sent out an order. Does either party object to that?
No, Your Honor.
No, Your Honor. Thank you. Each side will have 20 minutes to present an argument. Petitioner, you may save time for rebuttal, but as you know, you have to manage your own time because you're arguing from your table. You can work around if you want to see the time, if that helps. We are recording the argument both in audio and video. When it's your turn, please identify yourself and your client so that when we review the argument, we can keep everybody straight. The argument will be on YouTube in a day or two. We have read the pleadings, we've examined the law, we've conferenced the case, so we're familiar with the law and the facts. So when you begin the argument, just start right out with what you would like for us to know and to discuss with you. Counsel, you may begin.
Thank you, Your Honor. May it please the Court. Corey Langhoffer for the petitioners. Judge Kemp's order introduces 4 major innovations in the field of legislative privilege. The first of those is the requirement that a privileged document be tied to a specific bill. The second is that there's an independent showing of legislative impairment. The third is that the privilege is qualified rather than absolute where it applies. And the fourth is that public communications can give rise to a subject matter waiver. I'd like to start by talking about the fourth one, the subject matter waiver. I think we can all recognize that if public communications, hearing, for example, or the release of a report, can give rise to a subject matter waiver, this is a very significant part of the doctrine of legislative privilege. And yet, this part of the doctrine has evaded identification for the last 75 years or so when legislative privilege case law has developed. That is striking because if that were in fact the law, surely this would have come up before. Every major legislative act or episode is the subject of extensive public communications.
Counsel, who holds the privilege? Is it the body or is it the individual legislators?
Certainly the individual legislators can invoke it on their own behalf.
Then are you saying that they cannot waive the privilege?
There can be waivers. And we're not suggesting there cannot be waivers of individual communications or waiver of their privilege as to particular documents.
And those can be explicit or implicit?
So certainly an explicit waiver would work. I mean, there's no dispute about that.
Not implicit?
Implicit, our position is that if you intentionally release what might otherwise be the subject of a colorable privilege claim, you have waived that claim as to that communication itself. So for example, if the legislature says, we've prepared this report and here it is, they can no longer claim privilege as to that report. It's different though than saying that they've waived, there's a subject matter waiver over everything preceding that report, their internal thoughts about it, disagreements they may have, and so on. The idea of subject matter waiver, I think it's fair to read Fields as saying that there was a The language is fair, I think, to read it as a waiver of the subject of the testimony at issue there. So how do we reconcile them in PECO, which says, there's not a subject matter waiver over the preparation of the communication to the Attorney General, with Fields, which says there is something approaching a subject matter waiver? Our view of Fields is that it is limited to the attempt to invoke an evidentiary privilege in a judicial forum. This is not the traditional, pure form of legislative privilege like we have here. The acts that are alleged to give rise to waiver happen within the legislature. In Fields, they've crossed from the legislature to the judiciary. And the rules are different in the judiciary. There's cross-examination. It's an adversarial process. There's 26.1 disclosure statements where you have to say everything you know, all the evidence you have, the facts and so on. You have to disclose those to the other side. And if you're going to offer evidence, subject yourself to cross-examination on that. We cannot export those judicial standards to the legislature. If you spent any time in the legislature at all, and I know everyone in this room has, everyone on the bench has, a legislative hearing is not a judicial hearing. There is no full disclosure statement beforehand. It's not even necessarily adversarial. There's no rules of evidence. The people who ask questions, I'm sure you've seen the videos, especially from Congress, people asking questions usually testify and throw in a little question at the end. It is fundamentally different than what happens in the judiciary. And so Fields is saying, when you come into the judicial forum, and when you identify someone as your testifying expert, you accept the judicial rules. You don't have to say your own witness, your own consultant will be your testifying expert. But if you do that, you accept the standard rules that go along with it. Basically, in the judicial forum, legislative privilege can't be a sword and shield. You can't use the legislative process to develop your evidence and then shield yourself from cross-examination of your evidence in the judicial forum. There is no, if you look at, pick in your own mind a major piece of legislation. It could be the Affordable Care Act, it could be the Civil Rights Act, it could be SB 1070, pick in your own mind your favorite. Every one of those was a subject of television interviews and op-eds and floor statements and usually signing statements from the executive, in some cases judicial opinions about the constitutionality of those acts. Those statements, the governmental privileges, as distinct from the classic private privileges, attorney-client, doctor-patient, and so on, those public statements have not been found to be waivers. This idea that some public communication about a major legislative act is a subject matter waiver as opposed to a communication waiver, this is novel. And the reason it's never come up before is because that is not how we do it.
Counsel, let me jump in here for you. Let's assume that if we were to agree with you that there's no global waiver of the privilege here, then what? Where does the case go? It goes back to Judge Kemp. Is it then proceed perhaps with the amended privilege log or in-camera inspection? What happens from here if we agree there's no global waiver?
So I think that what would happen is, with American oversight, as distinct from Phoenix newspapers, they're not a part of this case, of course. We've had a meet and confer process. They've identified items in the log that they say, this one looks like it may not really be a good claim of privilege. Can you re-review it? And we certainly have, and produce those promptly if we agree with their position on it. I imagine we go back to the trial court and we would go through that exercise again.
Okay.
The privilege log, I'll speak to Phoenix newspaper's request for an expanded privilege log. I'm really at a loss as to say what else could possibly be in there. It's extremely long, as your honors have seen. It identifies the parties, the communications, the time, the subject matter. I don't know, I'm unaware of any case that requires a more detailed privilege log, and I've certainly never worked on a case that had a more detailed privilege log. And the remaining items are so few in scope or so few in number that I'm at a loss to understand the request for a more detailed privilege log. If there are, procedurally, we produced the log, we had a meet and confer about some items, and then they filed a motion to say nothing should be privileged, essentially. The legislative privilege is extraordinarily narrow. That leaves open maybe more refined arguments that this communication between President Fann and Randy Poland, for example, one of the legislative liaisons, may not be privileged because someone else was copied. Like they could raise those sort of document level issues, not a global argument about the scope of the privilege. I think that would remain.
And would that, would that apply to every document that's in the privilege law?
In principle, I don't know why it wouldn't. I don't think they've stipulated to any of their privilege claims being valid. So far, there's been no argument in the lower court about the attorney-client privilege claims, and they've never waived those. They've never waived individual claims about particular documents. So I think that remains. Our view, our shared view, I think it's fair to say, is that the most efficient way of proceeding this case was to determine what is the scope of legislative privilege, and then reserve for later disputes about how it should be applied to individual records. There could be some in-camera review, conceivably. That hasn't been an issue yet before Judge Kemp.
Normally, at least in terms of appellate analytical logic, we usually consider waiver first. So, would waiver be more of a threshold issue before having to get into the weeds on the extent and the scope of the privilege?
We already have a ruling from the trial court on waiver. In fact, yesterday we got an oral ruling from Judge Hanna in the Phoenix newspaper's case that also found waiver for I think, substantially the same reasons.
That global waiver?
Correct. Correct.
Counsel, speaking to that issue, the interaction between the public records law and legislative privilege is really kind of the kernel of the case. But the public records laws are a product of the legislature, are they not?
They certainly are.
So why then did the legislature not exempt itself, a la the legislative privilege, from the public records laws?
Well, Your Honor, first, just structurally, if the legislative privilege arises from the Constitution, the previous legislature could not waive could not through statute waive a constitutional claim of a subsequent legislature. And so we do not accept the idea that by passing the Public Records Act, the legislature waived all future legislative privilege claims that are constitutional in nature. Couldn't have if they wanted to. But they didn't want to, because the Public Records Act, both textually and in practice, has always recognized the right to withhold confidential or privileged records. There's never been a waiver of privilege, and for 30 years, the legislature has relied on legislative privilege and attorney-client privilege exceptions to the Public Records Act, really without incident. That's not unique. When you look at the governor's handling of public records requests or agency requests for public records, everyone withholds records based on viable privilege claims. And there's never been a dispute. I'm aware of no case that has even assessed the idea that by passing the Public Records Act, privilege claims are waived. It's not been the practice. I don't believe that's the argument here so much.
I think that's a fair question to ask, because in Fann 1, of course, our court said, well, the legislature could have exempted themselves from immunity. I mean, could have exempted the public records law based, but they didn't with regard to legislative immunity.
So, Your Honor understands Fann 1 very well, of course.
Maybe that was wrong. Tell me it was wrong. I don't know. So,
Fann 1 was not about the privilege issues, and
so they are different. I mean, it's acknowledged that they're quite different. Legislative immunity and privilege.
They arise from the same clause. Doctrinally, our view has always been that they're quite close, and Your Honor may have a different view. I will say this, though. Factually, there's something that happened in this case which is important. I don't know that's in the briefing. It's in the record. I don't know it's in the briefing. I'd have to look at this to be sure whether it was in the oral argument or in the final briefing before Judge Kemp before Fann 1. But the judge said, I think as I talk about this, it comes back to me. The judge at the end of the substantive argument before Fann 1, where do we go from here, counsel? And Mr. Beecham said, well, Judge, I think we need a ruling from you, and then there'll probably be some privilege claims, and we'll come back and work those out. The Senate lost that. Fann 1 followed and said you need to produce the records, and we came back to the trial court to work out the privilege claims. And so I think it's fair to say we had always reserved the privilege issue for subsequent litigation when Fann 1 was decided. I don't think Fann 1, there's no law of the case on the privilege issues here. I'd like to talk briefly about the independent showing of legislative impairment requirement, the second of the 4 innovations from Judge Kemp. That idea, there's something appealing about that, because when you look at gravel or when you look at fields, the text does say, impairment of legislative functions. But in practice, there has never been a requirement, there's independent evidence or an independent showing of that. If you look at fields, for example, in paragraph 32, it says, the mere disclosure of documents can chill legislators from participating in the deliberative function. It's effectively assumed by the courts. And you see the same thing in Minpeco from the DC Circuit, which described that sort of requirement as absurd. It's their word, not mine. On the idea of one more, I guess, the Miller case from the Ninth Circuit applied the privilege to a legislator who had retired or lost his last election. He had no, bona fide claim of impairment there. Just the fact of producing a record and the chilling effect that would have on the body was taken as sufficient evidence of impairment. There's no independent showing required. The DC Circuit, there are a few courts that have a special expertise. We look at the Delaware Chancery Court as saying it knows corporate law very well. Their decisions are more authoritative on corporate issues than, say, Indiana Supreme Court. And the Kentucky Supreme Court has a special expertise in horse racing, as it turns out. It's more authoritative there. The DC Circuit has that status with respect to the governmental privileges for reasons that are obvious. And when Minpeco in the DC Circuit says this sort of independent showing of impairment is absurd, that means something, that has some weight, because they've seen a volume of these cases over decades.
Counsel, I'm aware of the history where we have leaned heavily on federal interpretations of the privilege, but you would agree with me that Arizona's iteration of the speech and debate clause reads quite differently from the its federal corollary, would you not?
I certainly do. You can't argue with the text that's there. And yet, Fields rejected that idea, that because of the text, we should have a different test. And so I think we're bound by Fields. They rejected the idea that because of the textual differences, the substantive protection should be narrower.
But we're not bound by Fields, are we? I mean, we could disagree with Fields. We can't overrule it, but we could disagree with it.
If it can't be overruled by this court, that's correct. Your Honors, I would be happy to answer additional questions. Those are the points I hoped to make in our opening. I'd like to reserve the balance of my time.
Thank you, Counsel. Counsel?
Good morning. I'm Keith Beecham, representing American Oversight. Can you hear me all right? I'm used to being up there. I think I'm going to just really briefly touch on a couple of points that Corey made and then segue back to the extent I can to the comments that I had prepared. And I'll start at the end with respect to the Fields question. In footnote 4 of Fields, in dicta, it's clearly dicta, the court makes a statement that when the Arizona constitutional founders used different language than is in the federal statute, they were aware of the interpretations of the federal statute. The reality is the statutory provisions are very different, and in our case in particular, where at this point it's an issue of legislative privilege, not immunity, I think those differences are important for the reasons we set out in our brief. And I'll also point out that Justice Bullock, at least, also in dicta, has expressed disagreement with the footnote in Fields. And that's particularly true, I think, here when we talk about the intersection of the public record statute and legislative privilege, which I'll turn to in a moment.
So clarify that for me. What is the playing field? I mean, what field are we playing in then? Are we playing in the DC circuit, the Ninth Circuit, everything combined? Do we take all federal law, all state law, and just mush it together the best we can?
I don't respectfully don't know why you would look beyond Arizona law. The case...
But doesn't Fields rely specifically on the U.S. Supreme Court as the framework? I mean, it's gravel, isn't it?
It is, but I think the Arizona Supreme Court in the Steiger case, which I think doesn't get talked about enough in our brief, frankly, relies on and cites the various Supreme Court cases, but I think Steiger actually answers the question here. Steiger is what Fields built upon later, but Steiger says that the holding there was that there's no need for ongoing legislative activity for an investigation, and there the legislative privilege did not shield a congressman's aide from answering deposition questions in a civil suit against the congressman, even though, and I'm quoting from page 3, it, quote, involved an investigation related to legislative activities and motivations for those actions. I'm not going to read at length, but I think the language on page 3 and 4 of Steiger squarely goes to the issues that I think confront this court, and Steiger is binding on this court. To sort of swing back to the other point I wanted to make with respect to the question that you asked, Judge, about the intersection between about waiver and impairment of deliberations. In Steiger, the court said what all the courts are saying, which is the legislative act must be an integral part of the deliberative and communicative process by which members participate in committee and House proceedings with respect to the consideration and passage or rejection of proposed legislation, or with respect to other matters. That, I think, really goes to the heart of why this audit in general is not subject to legislative privilege at all, which is our overarching argument.
But counsel, isn't fact-finding for the purpose of legislative ambit, is that not part of the game? I mean,
it is, but it's not part of this case. That hasn't happened here. The legislature here has done nothing. A subpoena was issued to collect records or to collect the voting equipment. That's not an issue in this case. And since then, everything that's happened has been what President Fann has done using her office, but the legislature hasn't appropriated money, hasn't considered legislation, hasn't held committee hearings, hasn't done anything. In the Steiger case, to go back to it, in the Steiger case, the court talked there about how Congressman Steiger was conducting an investigation. 6 or 9 months later, I don't remember which, there were committee hearings, and about a year later he introduced legislation. And the court said, yeah, but a congressman, an individual legislator, can't just go out and talk to people and then later when they get sued for something that they did, avoid testifying. Now here, of course, we're, I think, much narrower than that. There's no individual lawsuit against President Fann, and there's no request to take her testimony. And here, of course, we have the additional impetus of a public record statute. But to get back to your question, the audit itself is not an investigation. What President Fann said on March 31, 2021, when she announced the audit, and this is at SA 130 in the record, and it's attached to our verified amended complaint, which has a bunch of other testimony, admissible evidence about waiver. She said there that the audit will be done in a transparent manner. It's being done, now I'm not quoting anymore, but it's essentially being done at the request of citizens, and now I am quoting, voters want the additional assurance that a full forensic audit might bring. Because it is an independent audit, leadership will not be directly involved. Members do not expect to comment on any of the processes of the audit until the report is issued. So here, President Fann, on her own volition, elected to initiate this audit, if you will, and the audit may well be, that report might be looked at by legislators down the road, and after that audit report was issued, today, tomorrow, last week, if President Fann has an email with some other legislator about legislation she wants to be introducing based on the audit, I think that will be covered by legislative privilege, very likely. But here...
So what about the statement of work? It actually uses the word investigation. In essence, it says that the audit will attempt to validate every area of the voting process, ensure the integrity of the vote, includes auditing the registration and votes cast. Then the final report will attempt to outline all the facts found through the investigation.
Labeling it an investigation, respectfully, is not the test.
Well,
That's the exact word that's used in Steiger. There was an investigation in Steiger, and the aide had to testify about it. Why? Because the investigation was not legislative activity. And the reason is...
Who authorized the investigation in Steiger?
The Congressman Steiger.
Okay. He's not the chair, he's not the
There was a
president?
subcommittee later, and he said, hey, I sort of did this, and then we had the subcommittee, and then he actually introduced legislation.
Nobody's disputing that Senator Fann didn't have authority to do this. I don't
think
see that
that's right.
argument being made, right? She signed on behalf of the Arizona State Senate.
Well, she signed in her role as the president of the state senate. There was no vote, and I don't think I want to speculate about whether she could have gotten the vote.
There's no
to do this.
judicial finding that she had no authority to do that.
Right, and the issue isn't authority.
Yeah.
The issue is, and this is really,
Understood.
this is the core of the case. It gets to the core of the case. To be protected by this privilege, what they're trying to do is prevent legislators from curbing their discussions with each other about their deliberative process for legislation. And so that makes perfect sense. But that's not what this is. These communications between her and Cyber Ninjas, or her and the subcontractors, or her and Ken Bennett, are not deliberative processes among legislators about legislation. Even if there's legislation later, the interest that the legislative privilege is supposed to protect, which is the public's interest, not the legislature's, is not involved. That's the primary point of why we've I think won in Superior Court, and why I hope we will win here, because they've not made the showing, because they can't make a showing, that there was any deliberative or communicative process underway, much less any impairment of that process. And their inability to do that under Steiger and other cases that we cited in our papers, I think answer the question. And in contrast, in Fields, for example, there the independent redistricting committee gets treated as if it were the legislature. There clearly were those deliberative processes underway, and that, I think, was the paradigm for the discussion in Fields. But here there's no deliberative process underway.
So you're saying, correct me if I'm wrong, you're saying there's absolutely no chance that any document that remains, or that's listed on the privilege log is subject to the privilege?
Correct.
Now, let me flip to the other case, for a second, the Phoenix Newspaper's case. Judge Hanna has apparently found one document that's partially protected by the privilege. I don't know if that's going to come up on special action. I don't know what's going to happen with this. I don't know what's in it, other than the brief description. Wouldn't his finding cut against your argument?
It would if Phoenix Newspapers had made the same arguments to him that we made. Phoenix Newspapers did not argue what I just said. They did not argue that the legislative privilege does not attach at all to the audit. And so there would be no reason for Judge Hanna, unless he, I guess, went beyond what the parties were asking, there would be no reason for Judge Hanna to say legislative privilege does not apply here at all. Now, I think in my case, to go back to the question I answered a minute ago, there's a theoretical possibility, certainly anytime there's a possibility, that two legislatures could be communicating about proposed legislation in a way that would fall under the privilege. But there has been no showing of that here, and the fact that the audit was happening that's their showing. Their showing is, well, we think the audit is enough to cloak communications about it. And if you look at the privilege log on the audit, although they throw the word legislative in there from time to time, it's clear they're talking about audit processes and procedures, even among the legislatures, I believe. And so that sort of gets to our burden point, and the burden point in the Menendez case, that Third Circuit case we cite, also in Steiger, in the Chartwin-Bernini case, they have the burden with respect to privilege. And ordinarily in an attorney-client privilege, their privilege log would be fine. And we're not contesting their log with respect to attorney-client privilege, at least not on any sort of global scale, because there's the name of a lawyer, there's the name of the client. They say what the subject matter was generally about, who am I to argue? But when it comes to legislative privilege and the three-part test that exists, they have to show as a starting point that they could fall under the umbrella. And their failure to do that is what I think brings us here, at least in part. There obviously are other issues, but that's a significant one from my perspective. Also, to go back to the answer that Mr. Langhofer, I call Corey, and I mean no disrespect. I know him well and respect him. So Mr. Langhofer pointed out that, or said that, in response to your question, Judge, that the legislature, although they're subjected to the public records statute, could not waive future constitutional claims for legislators. I'm not so sure that's true. I think they could pass legislation or do something with respect to the statute, and if the next set of legislators didn't like it, they could change the statute back, or a particular legislator could say that it doesn't apply. But really, more to the point about the interaction between the public records law and immunity is that the public records statute the privilege has to be construed narrowly. It is a privilege, it has to be construed narrowly, and that much is crystal clear. And the records that we're talking about, there's no dispute about it, they are public records. There's a strong public policy favoring the disclosure of public records. And the burden to demonstrate that a privilege that applies is on the party asserting the privilege. Here, and I said this a little bit already, but I'm going to make the point again, the public's right under the public records law to know what their legislators are up to would be restricted by a broad application of legislative privilege. And instead, I think the court has to weigh the interests of the public under the public records statute and the interests of the public, not the legislators, the public, under the legislative privilege. And I think when you weigh those two factors, even assuming the audit is legislative, and even assuming there was no waiver, I think the right result would be that the failure to meet their burden to show that these documents are privileged in the first place is dispositive.
But if we agree with you that that was not legislative in nature, or if we agree with your argument that there was no impairment shown, do we have to weigh? Do we have to weigh this different, or this, say that one has more weight than the other?
No, it only matters if there's a showing that legislative privilege applies.
But then explain to me how that works. Then you're saying that the public records law would, in fact, trump the privilege, what, in 5 instances? I mean, in some instances where it's like, how would you make that call?
Well, are you asking about in our case in particular?
Yeah, exactly.
So in our case in particular, and I'm more of a trial lawyer than an appellate lawyer, but you have to make your showing in your case in the trial court before you get up here, and there has not been a showing that legislative privilege applies. I'm not sure if I'm answering your question.
Judge Kemp left the door wide open. He said, I'm leaving the door wide open for in-camera review if either party requests it.
No, I don't think that's what he meant at all. In the hearing and in our papers, we made clear to Judge Kemp that we were reserving our right to seek in-camera review and to make particular document-by-document challenges if he elected not to accept our argument that the privilege didn't apply at all, whether by waiver or for the reasons we've already talked about. And so that's why he was saying that. I don't think, I guess you'd have to read the transcript to know that I'm right about that, but we made the point to him that we weren't waiving our right to seek in-camera review later, but we didn't think it made any sense to, and there are a lot of questions we would have about the privilege log, but we didn't think it made any sense to send letters or engage in a meet and confer with respect to potentially hundreds of entries in a privilege log, or send that to a special master when, in our view, the privilege didn't apply at all.
Okay, so the Senate is arguing, if Mr. Langhofer can correct me if I'm wrong, but one of the Senate's arguments is, look, it's global. I'm not talking about global waiver, I'm talking about global privilege. That's what they're saying. They're saying these 600 plus documents are all protected by the privilege. End of story. If we reject that, but we don't know what's in these 600, nobody knows, except the Senate, the trial judge doesn't know, we don't know. Wouldn't the next logical step be, perhaps if they want to pursue it, or are you saying they can no longer do that? Can they still put forward a showing to, say these 10, okay, or these 100, these are the best we have to show privilege. what you referred to as these legislator-to-legislator communications. Can they still do that, or you're saying that's over?
No, the time for that has come and gone. We made these records requests in April. We filed a motion to compel. They had the opportunity to respond. We submitted evidence in the record in a verified complaint and attached 30 documents that talked about waiver, talked about what the scope of this audit was about. In the response to their motion to compel was the opportunity they had to demonstrate that the privilege applies. And we argued, and Judge Kemp agreed with us, and I think he was right, that they didn't demonstrate that the privilege applied. So if you agree with us, or if you affirm Judge Kemp's ruling, or decline to accept jurisdiction in reverse, then the reality is there's nothing more to do. It's only if you conclude that Judge Kemp was wrong and say, no, there wasn't waiver, yeah, the legislative privilege might apply here, and send it back. At that point, we would then have the opportunity, because we expressly reserved it, to then address particular items in the privilege log. But I think unless you reverse Judge Kemp, I think the opportunity for the Senate to make a showing that they haven't made yet has come and gone.
So isn't that they've waived the privilege, then they've waived the argument?
It failed to make a showing. I don't know if I would describe it as waiver, but failed to make a showing. I mean, we have the big picture waiver argument, which is this whole process was all about public notice, and I'm not going to, you read our paper.
Global waiver, I call it.
Yeah, global waiver.
Okay.
But this point is really, if someone moves to compel the production of materials you withheld, even though you've given them a log, and their arguments are the ones that we made below and the same ones we're making here about how the privilege doesn't apply in the first place, because it's different than something like attorney-client privilege. That's it. We're not, it's not Groundhog Day. It's a public records case. It's supposed to be proceeding expeditiously. And then we get to see what those withheld records are. And I think that's the right approach, because this audit was not a legislative investigation. There's no showing of deliberative and communicative processes, and although the Senate likes to describe our argument as the document must be tied to a particular bill, that's not true. If the Senate were in session or were contemplating legislation, I think the legislative privilege is pretty easy to apply. But under Steiger and the other cases we cite in our papers, the fact that a legislator is out talking to people. Here, for example, there are lengthy text messages and emails between Senator Fann on the one hand and individuals who are unpaid consultants, advisors, whatever you want to call it, Phil Waldron, Ken Bennett, there's a host of them. That's not a legislative deliberative process. It's about the audit, and the audit hasn't been sanctioned by the legislature, and from our perspective, they haven't made the showing they need to make, because, and it's not a technical we got you argument. The whole point of legislative privilege is you don't get to withhold documents in the public's interest. You don't get to withhold documents unless it's serving the interest of permitting legislators to speak freely about legislation or proposed legislation, and there must be some impairment. You have to have some showing that allowing the particular document would impair that. That showing hasn't been made. They could have, and they elected not to submit a declaration from Senator Fann or anyone else about how this would impair their deliberations, what processes were going underway. The only evidence of a legislative process is that those words are used a lot in the report that came out in mid-September, and in that same time frame, Senator Fann sent a letter to Attorney General Brnovich and made comments about that they were going to try and enact some in the legislation based on what was in that audit. I think I'm over my time, so I'm happy to answer questions if you have more, but don't want to abuse it. Thank you.
Thank you. Counsel?
Thank you, Your Honor. I am candidly surprised to hear, or first to read on appeal and now to hear, that the legislature somehow forfeited the right to make an evidentiary showing. First of all, we've issued iterative privileges logs, each of which are hundreds of pages in length, containing itemized serial numbers for every withheld document, the dates, times, parties, content. This includes text messages, emails, I think some paper records. There's already been an extraordinary showing detailing the nature of the claims. And to say that there's somehow a forfeit of the right to do that is odd, because the showing's already been made. Second, we were very clear before the trial court that what we first wanted was an explanation from the court, recognizing this was likely to come up on appeal, of what are the parameters, and then we can fight about how to apply those parameters to individual documents. So I disagree with the idea that there's been some sort of forfeit.
So if this case gets sent back, then everything in a sense starts over?
I think that what we need in order to proceed to disputes about individual records, or to what would probably be the most efficient way, would be to hand the body of records that still remain in dispute, in some cases just redacted portions of records, hand them to a special master with the guidance from this court about what the parameters really are, and let them review our calls. I mean, certainly we'd be happy to deal with any individual concerns that American Oversight or PNI has to items in the privilege log. I suspect, based on the way the case has gone, that they object to everything. And they'll say, we are not confident that any of these roughly 600 documents are subject to the claim or the guidance you offer, so let's let a special master review them in camera. So I think that's what we need. We need articulation of the principle, and then we'll let a special master decide whether our application of that principle to the documents is correct.
And I suppose part of that analysis would be whether the particular communication is waived.
Well, there's already been a finding of waiver.
But I'm speaking of the individual waiver, not the global waiver that these Kemp seem to find.
I don't believe that the documents currently in dispute have been the subject, they've never been released. And so when something is moved into the public reading room, we note that on the privilege log, because it's gone, right?
Okay.
And we're withholding none of the floor statements, for example, or videos of the hearings. So I don't think the individual waiver would apply to those.
Thank you.
I'd be happy to answer more questions if you want, but I do want to just reiterate this point, and I've been accused of being overwrought for this, but let's not hide from the fact that Judge Kemp and now Judge Hanna's rulings will extinguish the legislative privilege in Arizona. In practice, it will not survive. If as written, it is affirmed, there's nothing left. And you can point to the one document that Judge Hanna found a portion of it, a fragment of it, is covered by the privilege. I naturally I can't say too much in a public forum like this about what it is, but it is a judicial record. Your Honors could look at it. I think it's fair to say it's sui generis. The discussions that the legislators had about the audit would not be protected by the standard articulated by Judge Kemp. And that dismissive approach to privilege is not consistent with the way the judiciary has treated its own privilege or the executive privilege, and these exist for a reason, to encourage candor and, frankly, improved results in what is supposed to be a deliberative body. Thank you.
Thank you, counsel. We appreciate your arguments today. We will take this matter under advisement and will issue a decision in due course. Thank you. We stand adjourned.